Need to go start there. Oh, that's. All right, Mr. Schmidt, who are you ready on?
Roger Bridges.
Bridges. Yeah. This is cause number CR 24-299, State of Texas versus Roger Neal Bridges on the state's motion to adjudicate. Next time we'll have them go the other way. Next time we'll have them go that way when we have the public in here. We're gonna have them go that way. Go ahead. Announcement on motion to adjudicate.
Judge, we were asking for a reset on that. I think the state did you indict a new offense on Mr. Bridges? They just opened up the discovery for me to review. I think that's one of the bases for the motion. So we're going to ask for one additional reset. In addition, we received an offer from the state yesterday. Need to sit down with Mr. Bridges to consider it.
Any objections from the state?
No objection, Your Honor. Thank you.
All right, court will set Mr. Bridges for May 28th. All right, and then calls number CR 24-183. In that case, you appeared before the court on September 24th of 2024. Also on burglary of a habitation. Court followed an agreement that placed you on 5 years of deferred community supervision and alleged in a amended motion to adjudicate or revoke also 5 allegations. So he's pleading true to those 5 counts and that cause number as well, and also waiving the reading of that motion to adjudicate.
Yes, sir.
All right. And it appears in that case, as you were saying, Mr. Schmidt, that the agreement is upon its plea of true that the amended motion, pleading true to the amended motion to adjudicate. Recommendation is defendant's guilt be adjudicated, community supervision be revoked, and punishment be assessed at 8 years confinement. The Texas Department of Criminal Justice for the balance of his financial obligations, which includes fines, court costs, and reimbursement fees. How much credit time would Mr. Jenkins be entitled to on that cost?
On the MTA, Judge?
I think they're both MTAs.
Shouldn't be. One of them is we're pleading to a lesser included. It was indicted as burglary of habitation, but it's actually a criminal trespass of habitation. So that one is a new offense. It should be a straight 34 days in the county jail with credit for 34 days. And then on the other one, he has, give me 1 second, I'll pull those. On the CR 24-183, he should have 338 days credit time.
338.
Yes, sir.
All right, Mr. Jenkins, is that your understanding of the plea agreement in both cases?
Yes.
All right, and the court will note that the cause number CR 24-183 is a motion to adjudicate, and CR 25-126 is a new offense. All right, then, Mr. Jenkins, at this time, I would ask you in cause number CR 24-183, how do you plead to counts 1 through 5? Are those counts true or not true?
True.
And has anyone threatened you, forced you, or pressured you to plead true to any of those counts?
No.
And cause number CR 25-126 on the charge of criminal trespass of habitation, how do you plead to that offense?
Guilty.
Are you pleading guilty because you are in fact guilty of committing that offense?
Yes.
Has anyone threatened you, forced you, or pressured you to plead guilty to that crime?
No.
All right, the court will accept the defendant's pleas of true and plea of guilty respectively in each cause. Mr. Schmidt, any objection to the evidence being admitted?
No objection.
Evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, in CR 25-126, state is in compliance. No communication was, no BIS was received from the.
Thank you. Anything further from the defense?
No, sir.
All right, court having reviewed the evidence finds enough evidence to convict the defendant in cause number CR 25-126. Court hereby follows the plea agreement. In recommendation of the state, the court hereby convicts Isaac Anthony Jenkins of criminal trespass of a habitation, a Class A misdemeanor, assesses punishment at 34 days confinement in Van Zandt County Jail, orders him to pay a $500 fine, court costs of $270, and reimbursement fees of $535. And the court awards him 34 days credit towards his sentence for the time that he has spent in jail on that cause. In cause number CR 24183, the court finds counts 1 through 5 in the state's amended motion to be true. The court hereby adjudicates the defendant's guilt, convicts the defendant of the second degree felony offense of burglary of a habitation. The court hereby revokes the defendant's community supervision, finding that he's violated terms and condition. Court assesses punishment at 8 years confinement at Texas Department of Criminal Justice and orders him to pay the balance of his financial obligations. And the court awards the defendant 338 days credit towards his sentence for the time that he has spent in jail on this cause. All right, Mr. Jenkins, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. We're going to take your fingerprint and then you'll go have a seat. All right, Mr. McInturf, if you'll raise your hand, I'll place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So if you go ahead. Yes, Your Honor. All right, thank you. All right, Mr. McInturf, you've been charged by indictment or actually by information with a collision involving damage to a vehicle greater than or equal to $200. Is this a reduction to? Says that he on the docket says it's aggravated assault with a deadly weapon, but this says
Yes, Your Honor.
information for Class B, but it's the same offense. No, actually, this says CR 2640. This says CR 264. See,
Yes, Your Honor. I filed a CNI yesterday to affect the plea.
there's a 0 that's after the 4 I didn't see. Okay. All right. So Mr. McInturf, you were charged with aggravated assault with a deadly weapon, a second degree felony in cause number CR 26-4. The state's moving to dismiss that today based on insufficient evidence. You've also been charged by information in cause number CR 26-40 with the Class B misdemeanor offense of collision involving damage to a vehicle greater than $200, a Class B misdemeanor, which carries a range of punishment of not more than 180 days and a possible fine not to exceed $2,000. I see that there's a plea agreement in your case that you would be pleading guilty to that in exchange for the state's plea agreement and recommendation of 179 days confinement in the county jail, for which you would receive 179 days credit. In addition, you would be ordered to pay a $500 fine, $270 in court costs, and $515 in reimbursement fees. And the state is asking the court to dismiss FC 26-27, which is a criminal mischief. Is that your understanding of the plea agreement today, Mr. McInturf?
Yes, Your Honor.
All right, Mr. McInturf, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Schmidt. Are you pleased with him as your attorney?
Yes, Your Honor.
Do you understand everything that you've read and signed?
Yes.
Do you have any questions?
No, sir.
Mr. Schmidt, do you believe your client to be competent to enter into an agreement? And if so, he's doing it intentionally, knowingly, and voluntarily after understanding his legal rights?
Yes.
All right, Mr. McInturf, to the charge of collision involving damage to a vehicle greater than $200, how do you plead?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, Your Honor.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, Your Honor.
Court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulated evidence?
No objection.
Evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from state?
Your Honor, just so that the record's clear on everything. Both of these cases came out of the same course of conduct. We didn't feel, after speaking with some witnesses, that the aggravated assault, that the evidence was there, obviously, so we refiled it. The reason it's being pled to the misdemeanor B is because I didn't think that was an actual lesser included, which is why the new cause was filed. However, in addition to that, Your Honor, there was no, in the aggravated assault case, since the misdemeanor was filed yesterday, there was no victim impact statement or restitution request returned in that, and it's the same, all of the same actors involved.
Okay, thank you. I appreciate that. That does help. Anything further from the defense?
No, sir.
All right, court's going to review the evidence. All right, the court having reviewed the evidence, finds enough evidence to convict the defendant. Court will follow the plea agreement. Court hereby convicts the defendant, Robert Walter McInturf, of Class B misdemeanor collision involving damage to vehicle. Assesses punishment today at 179 days in county jail. Awards Mr. McInturf 179 days credit towards that sentence. Court also assesses a $500 fine, court costs of $270, and reimbursement fees of $515. Court also dismisses under section 1245, clause number FC 26-27, criminal mischief. Mr. McInturf, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you are fingerprinted, then you'll return